Good day, everybody. Welcome to another Faith-Seeking Understanding. I am Allan, your host. I am a pastor, retired, a professor, Bible moth, theologian in exile, and a peddler of hope. And I am the self-appointed Anselm of Canterbury, chair of podcast theology and culture here at Faith-Seeking Understanding University, a completely fabricated institution of higher learning where all people are invited to ponder profound things free of charge. Michael, I wonder if that shtick is getting old.
I don't know, but it's very true.
It is. It's all true. It's all absolutely true. Yeah. So anyway, Michael Cruz,
Yes.
here on Calmly Considered, who is the Grand Poobah Chair of Economics and Public Theology here at FSUU. And before we get into the conversation, I want to do something new today that we're going to do.
Yes.
I haven't done this before, but I'm going to tell those of us who are watching us on YouTube, if you get a chance, please click the subscribe button. That helps us get exposure. It doesn't cost anything. Just click the subscribe button. Leave us a thumbs up if you like an episode. If you dislike an episode, you can give us a thumbs down, but be gentle because we have fragile psyches. And by the way, if you have a topic you'd like us to discuss in the future, put it in the comments. I mean, we can't guarantee that we will discuss it. You know, we kind of, we'll draw the line at the mating habits of capuchin monkeys. But unless Michael, I don't know, you're a widely read guy. Maybe you've read on that.
Just happen to be an expert on that one.
But leave suggestions for us. We'll try and accommodate that if we can. All right, now, Michael, how are you?
I'm doing great. Doing well. My Royals have won 6 games in a row.
Your Royals are hot, and my Guardians are, I don't know. They've made some interesting trades, and there are some Cleveland fans or Guardian fans who are in a panic saying we've already given up on this season. I don't tend to think that. I'm a big fan of Tito Francona, and I think he makes good decisions, and so I don't think he's given up on it at all. I think he's trying to position us for a playoff run, but is also thinking about the future. But it is just kind of interesting to watch this kind of play.
Yeah. It is. Well, I mean, I was looking last night, had the Twins lost last night, there wouldn't have been a team in the American League Central with a winning record. And meanwhile, in the American League East, all the teams have a winning record. So, the Guardians are in second place in that Central where nobody has winning records. So they've still got plenty of hope.
Yeah,
the American 21 games back. We're not going anywhere, but it's fun to watch them win 6 games in a row.
Absolutely right. The American League Central, where mediocrity thrives.
Exactly.
Anyway, all right. Well, let's get to the subject at hand. This one I'm excited about, Michael. I think this is going to be a good conversation. The Supreme Court, guardians of the Constitution or judicial legislators? Depends who you talk to. It depends who gets the decisions they want. You know what I mean? So let me just begin quickly with a couple of things, and then we'll move forward. I want to read from Article 3, Section 1 of the Constitution that makes for the court. It says, the judicial power of the United States shall be vested in one Supreme Court, and in such inferior courts as the Congress may from time to time ordain and establish. The judges both of the Supreme and inferior courts shall hold their offices during good behavior and shall at stated time receive for their services a compensation which shall not be diminished during their continuance in office. All right. That's it.
Okay.
That's the Supreme Court. Now, a little bit of history here to get into the justice situation. So when the Supreme Court started under Washington, there were 6 justices. And, when people hear that, they immediately think 6. Well, man, you have a lot of tie votes. Well, in the early days of the Republic, they weren't worried about that because the vast majority of judges were Federalists. So, So again, so we can define our terms here. Federalists like Washington and Adams tended to believe that we needed a strong central government. So they wanted to ensure that. So they wanted to put more power in the hands of the federal government. Whereas Republicans, do not think today's Republican Party. The Republicans of Thomas Jefferson, I think they were initially called the Democratic Republicans. They much more believed in decentralization or states' rights, that they wanted more power to be given to the states. They did not want a real strong central government. So you get 6 justices at the beginning. The Federalists are in control, so they're not really interested, worried about tie votes. So it started with 6, but right from the beginning, politics enters into it. So John Adams is president. He loses after his first term to Thomas Jefferson. Okay, Adams is a Federalist. Jefferson is a Democratic Republican, and after the election and before Jefferson's inauguration, the Supreme Court Justice, this Chief Justice of the United States, resigns. Adams, we have this long conversation: should presidents make appointments after elections? After they are going out of office. Adams didn't care about that. He appointed Chief Justice John Marshall, who still is probably the most influential figure on the court. Right. Who really shaped the court, right? And he served for I don't know how many years. And the other thing he did, just to thumb his nose at Thomas Jefferson, was he reduced the number of justices from 6 to 5. So to keep Jefferson from making an appointment during his Oh, Michael, the stories are the same. The names have been changed, but the guilty are still there, right? Now, I want to stop there because I'm talking too much. I want to continue this. That's fine. I want to get your response.
Well, I'd just say history repeats itself. History doesn't repeat itself, but it rhymes. And I think one of the things to emphasize is that in the creation of that Supreme Court, and I think it's probably still true today, this idea of a court, and I should say it's not explicitly stated in the Constitution that the Supreme Court has the ability to review laws, although many of the founders had assumed that in their own writings and had said that. And there were state Supreme Courts, essentially, that were already doing that. So a lot of them made that assumption, even though it's not explicitly stated. But that ability to do that is extremely unique. I don't know if there's another country. I don't think there's any other major power in the world that has a government system set up like that. So this is something really new that the United States set up, with this ability of a court to review both the laws that are made by Congress and to review the actions of an executive in the president's role, to be able to declare those unconstitutional. So it's also very good.
Along with that, I don't think we realize how important for these early founders the law as something that administers justice. It was, when you read, in many ways, they're still working all of this out. But John Adams, when he is a young lawyer, defends the soldiers of the Boston Massacre. Not a popular thing for him to do, but he does it because he says that in a free country, no one should go without counsel. So he's got this moral position that even if the worst villain and everybody knows is guilty gets arrested, that person is entitled to a fair trial.
Right.
But so for example, it's during the Boston Massacre that Adams uses the language of guilty beyond reasonable doubt. That enters into the vernacular right then. So this stuff's kind of happening on the ground. Right. But they're concerned that the law provides guardrails against tyranny is really important.
Yeah. Equal justice under the law.
Equal justice under the law.
Over the Supreme Court building. I think that's etched in stone.
Yep. So anyway, to get back to Adams real quick. So Adams leaves office. Jefferson, he's got his 5 Supreme Court justices. John Marshall, by the way, is Jefferson's cousin. And they don't get along. Well, let's say it this way. Jefferson seethes at his cousin's decisions on the court because every time Jefferson wants to do something, the Supreme Court manages to say, no, you can't do that. So they're actually, at one point, now remember, Jefferson doesn't have a hand in writing the Constitution of the United States because he's off in France. He's an ambassador. Right. So during his administration, he tries to abolish the court. He wants to abolish the court as it's getting in the way of the will of the people. Well, of course, this doesn't happen.
Right.
So the 9 justices that we have, really, the first time that happens is 1869. For sure. Lincoln increases it to 10, again, for the same reasons. Court packing, we're calling it. And one of the reasons it goes to 9 is simply because as the country is growing and you have circuit courts and more circuit courts,
right.
Remember, justices are assigned circuit courts,
right.
where they review petitions from circuit courts. And remember, it isn't today, like a lot of it, I'm sure, is done by email and fax, and we don't use fax anymore, phones and things like that.
Right.
Supreme justices have to ride. They got to go to these places. So you need more justices. So we get 9, and that's the standard. Roosevelt it gets really irritated because the Supreme Court is not giving him a lot of what he wants during his presidency. So he comes up with an idea to increase the number from 9 to 15 justices. He's going to really pack the court. Problem is, he's got a Republican Congress, and they ain't going to let that happen. So it doesn't happen. So what I want to say here, Michael, and this is kind of one of the first things I want to talk about, is we've got 9 justices. Again, the Constitution does not mandate number. I personally do not see a reason ever to increase that number. I don't know what judicial law you can make other than I don't like the decisions the court is making. So we need to make more justices so that we can get what we want. The problem is, Michael, that's a short-sighted political perspective. Because if you increase it, it to 11, at some point that's going to come back to bite you.
Right.
Then politicians are famous for doing this stuff.
Yes.
I can't see a reason to diminish the number, but I sure can't see a reason to increase the number. I think 9 works out fine, and it's worked out fine. What are your thoughts on that?
I agree. I mean, I don't think, as you said, there's always been rancor about exactly what the Supreme Court's supposed to do, and are their decisions the right decisions, and so on. So there's always been an element of that. The system that is set out in the Constitution is an ideal system, and it is an ideal system that is occupied by imperfect people. And so it will never be perfect. And so the idea is it sufficiently good enough that there are checks and balances that hold that Supreme Court itself within certain guardrails? It's trying to hold the legislature and the executive branch within certain guardrails. But I think there are political guardrails that hold the Supreme Court check as well, too, because the Supreme Court doesn't have an army. They don't have a police force. What they have to rely on is the people granting them the authority to acquiesce to what the decisions are that they make. If they go too far to the extreme, then you could simply have a president refusing to enforce what the Supreme Court says, or legislatures just ignoring the Supreme Court. So they, to some degree, have incentive not to go outside the guardrails very far either. And that's where a lot of this comes in. We keep looking for the perfect system, where the system itself is what's going to ensure that we don't have corruption or bias in that type. There is no system that does that.
Right.
And there's systems that place checks on it to keep it from going to extremes. But it's always up to the citizens, the people of the country, to keep their institutions from going off the deep end and to get tools to do that.
And I think, I want to say here that I actually think John Roberts, our current Chief Justice, I think he has a concern about that. They're keeping the guardrails in place because of some of the ways he's voted on certain decisions, which are not necessarily decisions that you would think a justice with a more conservative judicial philosophy would vote. That doesn't mean that he always has to toe the line, but he does have a sense that he doesn't want the court. It's not good for the court to run away to either extreme. I think he's got a sense of that. Right.
Yeah. Right.
I also found it interesting recently, because I do want to talk about the kinds of questions that come up recently with Supreme Court justices and ethics and currying favors. I found it interesting that Justice Alito recently said that the Congress didn't have any power to impose ethics conduct on the Supreme Court justices, and I'm not sure where that came from.
Yeah, where's that in the Constitution?
Where is that in the Constitution? And judges, the Congress has impeached judges. So I'm not so sure where he gets that. I want to talk about that in a couple of minutes, because I do think the question of being above reproach matters. Right. Yeah, you're right. The system is not perfect. You get bad decisions, you get this, that, or the other. But at the end of the day, people in positions of power and authority need to be above reproach, and that includes also being very concerned about even appearance of impropriety. And so I'm very disconcerted that, I guess we're talking about this now, I'm very disconcerted that some of the stuff that's come out recently about Clarence Thomas, Samuel Alito, and I think some Justice Sotomayor too has had some questions about what appears to be currying favors with people who may have a stake in upcoming decisions by the court. I find that really troubling. And again, on both sides. And just to give you an example, I was always a stickler about this when I was a pastor, and I would have people, when I was at a church, I'd have somebody who owned beachfront property somewhere, and they would say to me, anytime you want to use the house, free of charge, we'll let you do it, and I thanked them for that, and I never took them up on it, because as much as I would love a week at the beach and not have to pay for a beach house, I was concerned of the optics of that. I was concerned that that if we had a difficult decision to make at the church or something like that, and I gave my support behind somebody who was doing those kinds of things a lot for me, that would not look right. And I refused to do that. I refused because I didn't like the looks of it.
Right.
I mean, I think when you're in these kinds of positions, I'm sorry, Clarence Thomas. I mean, I think if somebody wants to give you a fishing trip to Canada, who is somebody who knows there's a decision coming up they have a stake in, I think you need to say no. I think you need to say no. I have concerns about this. What are your thoughts?
I totally agree. I mean, as I was saying a second ago, the Supreme Court's ability to be a functioning institution relies almost entirely on the goodwill and the belief that they are going to operate impartially as a court. And so even the appearance, it's not just a matter of not doing things wrong, it's avoiding the appearance of even doing things wrong. Because you need to manufacture, not manufacture is not the right word, but you need to consistently reinforce the idea that you are going to be impartial on the court. And that it just sends, whether it's harmless or not, it's not harmless in terms of what it does in terms of eroding people's trust in what's happening with the court. So I think that's how I look at it.
That's good. That's good. So one thing I don't want to do here is get into specific decisions and talk about them, because that's that in popular conversation, that's really what the discussion centers around. And it should. I mean, I'm not saying it shouldn't, but I also think that sometimes what often gets lost is just the judicial process and looking at the law and deciding laws. It is my conviction, and I don't think I should have to defend it, but I believe that when the average American says something is or isn't constitutional, what they really mean is that's a law I agree with. I like that law, therefore it's constitutional, or I don't like that law, therefore it's not constitutional. I don't expect people to have any other different opinions. We're not, you and I are not trained in constitutional law. But that's not the way it works. You don't decide. I don't decide what I like must be constitutional, and therefore what I dislike is unconstitutional. And you told me a month ago when we were talking about the recent decision on affirmative action that you tried to find. I'll stop there. I'm going to let you tell the story because I think it illuminates the problem.
Yeah, well, I mean, I rarely watch cable news anymore. I just find it too annoying. But occasionally, when a breaking story pops up, I go on to the cable news to see what informed people, their pundits, have to say about the ruling, so I can learn a little bit more about it. I like hearing what they have to say. So as I'm going from one channel to the next, all I'm getting is how this is going to harm this group and how that's going to hurt these people here. And I'm like, how do I know that? What is in the ruling? What did the ruling actually say? What was its rationale and what did it say? And I kept going from channel to channel and back and forth and listening to all these people talk, and I could never get the answer. And I went online and I started searching news stories. And I think finally, about the third or fourth try, I got to an NPR story that laid out, in quotation marks, here's what the thing said, and here's how they rationalized the and I'm like, finally, thank you. So I'm trying to figure out what was said, and from there I can begin then to think about what are the implications of this, and what do I think of the ruling. And like you said, I'm not going to get into the specifics of what I think about that ruling, but the reporting always going to the consequences. And of course, if you're pro the consequences that come out, it's a great ruling. If you dislike the consequences of the ruling, then it's a terrible ruling. Neither of those say anything about, is it in the Constitution or not, and what was the reason for deciding what they decided?
Yeah, or whether that's
what I want to know.
Yeah, or whether it's a competent reading of the Constitution. I mean, this is what we don't get into. So one example, real quickly, as close as I get to a conversation on a specific issue, the Dobbs decision on abortion overturning Roe v. Wade. In this country, there has been what I would call a very reasonable disagreement over whether abortion law is in the purview of the federal government or in the purview of the states.
Right.
That has been a reasonable judicial disagreement. Okay.
Right.
I don't care what side you fall on. That's been a reasonable disagreement. But that's really not the center of the conversation publicly.
No. Yeah.
I think a woman should have the right to choose, so the government should say no. No, you can't outlaw abortion. Pro-lifers say, I think abortion ought to be outlawed, so it needs to go back to the states. And now that it's back to the states, let's see if we can try and make further laws to restrict it. Let's even make laws that will if a woman from Texas goes to Colorado and gets an abortion, she comes back, she's going to be arrested. So it isn't about this judicial argument about the authority of the federal government versus the states. It's I want this or I want that. And so I'm going to do by hook or crook whatever I can in the law to get it done. This is not the way to run a court. This is not the way. It's just not the way.
Right. And if you are what's the word I'm looking for? If you are doing your job correctly on the court and you're truly trying to decide what the Constitution says, and you do that accurately and do that well, there's a good chance in many cases that you're not going to be liked by anybody. And because of what you've got, because their focus is not what does the Constitution actually say, their issue is the outcome that they want to get. Right. And that's why I think it requires people of a particular mindset and of a particular backbone to be able to be a Supreme Court justice, to do that kind of stuff well. Yeah.
Well, again, I'll say this before, this has been one of my mantras on all kinds of things. You can't listen to the politicians. You can't listen to the politicians because their job is not to do exactly what you just said. Their job is to spin this in their politics. And so just turn them off. Just don't listen to them when they talk about these kinds of things. Right. So let's talk. So as we get into that, let's talk about reading the Constitution and interpreting. This is an important issue. It's important for me. I'm trained. I was trained in New Testament. And part of what you're trained to do is read texts. And reading the Constitution is really no different from reading the New Testament or, frankly, Michael, reading the newspaper that we all interpret. So the first thing that we need to say is when people say don't interpret the Constitution, just read it as it is. That does not happen. That does not exist in any world. We all interpret. We all bring our convictions, our biases, our stories, all of that into what we read. And so when someone says we need judges who will just read the Constitution and not interpret it, sometimes it's called strict constructionism. There's no such thing. That's not the case, is it? We all and judges have judicial philosophies. We talk about this, whether it's more conservative or liberal. I think it's more important, or I shouldn't say that. I think it's more illuminating not to call them judicial philosophies, but call them interpretive bents. That we are all bent on how to read texts. Intent is important, what the writers initially, absolutely, but it's not just intent. By the way, there is something called precedent, stare decisis, which is the tradition of interpretation. So it isn't just what the founders meant when they wrote something. It's what courts down through history have interpreted it as how to understand it. So the point is that we bring these things to our interpretation and our reading and the Constitution. So when someone says from either side of the aisle, the other side is just step it on the Constitution, or they're shredding it and ripping it. Well, no. There are, and I want to say, Michael, you're a Presbyterian. I'm a United Methodist. Boy, if you want to see competing readings of Scripture, just become a mainline Protestant. Nobody is saying that the Bible is not important, but we're sure reading it differently. Okay, I'm done. So go ahead.
Well, it's like, the model for structuring churches is right there in the Bible. That's why we have everything from Baptists to Roman Catholics. It's it's just all right there. It's easy to interpret, plain reading, right? I think there is this is going to extremes on either end. There, like you said, there is no strict interpretation of, a strict, what I was trying to say, literal reading of the Constitution. That's all that you can do. There's always layers on top of that. On the other hand, the Supreme Court is not just a super judiciary either that looks at things and says, oh, well, they once said that. Well, now this is what's more in vogue. Let's go do this thing instead. So they are bound to some degree by those things that are in the past. There's I was trying to remember what it was. I think Chesterton said something that tradition is the what was it? The prison of the
tradition is the living faith of the dead.
The living faith of the dead, but I that wasn't the exact quote. Well, anyway, I don't have the quote.
Tradition. By the way, I think that's Yaroslav Pelikan, the church historian. It's tradition is the living faith of the dead, and traditionalism is the dead faith of the living.
There you go. Well, here's the one that I was thinking from Chesterton. Tradition is the democracy of the dead. That's what I was looking for. And Peter Kreeft was writing, progressivism is the elitism of the living. That was his. So he was talking about those two. And so there's this sense of which we're smarter today. Those people didn't know what was in the past. We know better now. So we can just ignore what was said in the past and do this thing instead. That's also not an incorrect interpretation of the Constitution. Somebody posted recently on Facebook, had this thing that said, rather than reading the minds of white slave-owning men who have been dead for 2 centuries, maybe we should just do the right things for people who are alive today. And so there's this sort of idea that, well, that was written 200 years ago. It doesn't have any application for us today. Let's just do what we think is right.
There is
That's not the Supreme Court.
There is this hubris, and so you have to take a look at the whole tradition and the history of interpretation. You also have to say, okay, we are in circumstances that were not the circumstances of the founders in many ways, and that makes a difference for how. One of the things that strikes me, Michael, is that that the law tends to follow society's customs and values. So, just think about the amendments to the Constitution. We had we could an amendment to give women the right to vote, to give African Americans citizenship and the right to vote, other amendments. those actually tended to happen,
right?
Because the culture was moving in that direction.
Correct. Right.
Now, I'm no Jefferson scholar, right? I mean, I've read Jefferson, and I've read a lot on Jefferson. I'm not a scholar. I have a hunch. I shouldn't use Jefferson here because he didn't write the Constitution. But I would have a hunch that if you ask certain persons who wrote the Constitution in 1789,
right,
if blacks should vote,
yeah,
they would say no.
Right.
They're not intelligent enough. We get a lot of this, we get a lot of this from the writings of the day. And so if you're going to take a quote unquote strict constructionist view of the Constitution,
right,
we should never have amended it.
Right.
Same thing with women, by the way.
Yeah, right. Well, yeah, and I think that's the issue, is that they wrote the Constitution knowing that things would change in the future. And despite all of their best efforts and the wisdom that they had at the time, they were not going to foresee and anticipate every potential conflict that could come out. And that's why in the Constitution, you have the ability to amend the Constitution. Right. And so you have a process for correcting those areas that you think are wrong. And so I think at one level, if you had tried to imagine every potential nuance and outcome that could happen from these large principles that are stated in the Constitution, we'd have a Constitution that would be volumes. There's no way you could lay out what all those are. Yeah. And so as events have happened and there was conflict and they needed to be decided, those things have emerged. Those aren't explicitly stated in the Constitution. And so then it becomes a more gray kind of, what's the just way to resolve this particular conflict between people's rights and what they want to accomplish that isn't explicitly resolved by the Constitution. You've got to figure out a just way to do that. The other thing is, too, that through amendments to the Constitution, sometimes we pass laws and sometimes we pass amendments that have consequences that we may not fully appreciate, that could be good or bad in terms of how they develop. And I go back to thinking about at the end of the Civil War, the 14th Amendment. And I remember reading on that when I was in graduate school years ago, several books talking about the 14th Amendment that basically said that you couldn't violate the rights of a citizen of the United States. Well, states had all these laws, for instance, a state church. There are a handful of states that actually had a preference for a particular denomination. You had other laws that restricted speech and things that states had. Well, one by one, and this is like a period of over 70 or 80 years, not in a decade or two, that each of those rights that are in the Bill of Rights, those first 10 amendments to the Constitution, were then applied also to the states. It was originally designed that was only going to apply to the federal government. Well, then once the 14th Amendment came along, whether consciously understood or not, that 14th Amendment now said that all of those things that the federal government can't do, the states can now not do either, because every citizen of a state is also a citizen of the United States. And so therefore you can't violate their federal liberties. So did they think about that from the beginning? Well, you had to have justices that looked at the Constitution and were creating new guidelines and prohibiting certain behaviors that had never been prohibited before, because something had changed in the Constitution and there was disagreement now about how that should be interpreted. So this idea that the Constitution doesn't lay out every possible disagreement that could happen, and the fact that the Constitution does change over time with amendments, which then creates new gray areas that have to be resolved, those can't be solved by strict literalist reading very often. And also just come to the fact that sometimes the conflicts that we get into are two legitimate competing rights that are against each other, that are both protected in the Constitution, but both can't be realized at the same time.
Yeah.
And so then how do you reconcile what that is? Who decides what the balance of behavior is supposed to be? So a lot of those become balancing acts, and that balancing act, there's no white line there's no white line as to what's right and what's wrong in those. And so anyway, you get what I'm saying, is that there's a lot of murkiness, a lot of grayness in a lot of these that does not allow for the often strict, it's this way or that way that so many pundits went
Yeah,
to.
for all the arrogance of the Enlightenment of the 18th century, and some of our founders wholesale into that, for all of that arrogance, there was a realistic humility in providing for the Constitution to be amended, because
Right.
in countries where the Constitution cannot be amended, you end up having to write a new Constitution periodically.
Exactly.
And you know, it's real interesting, Michael. I think most people don't realize this, but I can't remember if it's every 10 or 20 years. You on the ballot, if you go to vote in every 20 years, there will be a question on whether or not we should have a constitutional convention.
Yeah.
And of course, it never passes. I always vote yes, because I'm just, that's me. I'm just always, I'm a contrarian. So when that question comes up, I say, yeah, let's have a constitutional convention. That'll be a lot of fun.
It'll be fun. Yeah.
But the point is that the founders realized there were all kinds of things that were going to come our way that they had just didn't anticipate. And so what they provided us was a framework. But you've got to, so the way here's what I say with theology and doctrine. So I and see if I can draw a parallel here. I say doctrine is the house in which the church lives. Doctrine is the foundation. It's the studs, it's the 2x4s, it's the trusses, it's all the stuff that makes the house available to stand and makes it look. Theology is the way we move through the house. Theology is the way we decorate the furniture in the living room. Theology reflection is done within the context of that constitutive doctrine of ours. And I kind of think that analogy works here. The Constitution is sort of the house in which we live as Americans in reference to the general understanding of law. And then the rulings of the courts and the laws that we pass or don't pass are the way in which we live within that house. And the persons who built the house didn't envision where you were going to put the dining room table or what color you were going to paint the walls, They built the house. So the framers of the Constitution built the house. It's up to us within the confines of that structure to then make the house a home in which we live in and order our society. Now, is that a fair comparison?
Yeah, I like it. I think that is a fair comparison. There needs to be some level of adaptation to be able to deal with changing circumstances.
Well, think of amendments. Think of amendments as additions to the building.
There you go. It's all right. Additions or remodelings of aspects of the house. And occasionally we put on the addition and realize that was a mistake, and we take it back off again. Prohibition.
It's one of the great things that with the law allows us to say, "Oops, we goofed." I mean, we made a law we should not have made. Now it's time to get rid of it. Sometimes as you talked about decisions and we can't see all the consequences. Sometimes when you make a law and human beings, sometimes when we human beings make a decision at the time, we think it's a real good idea. And then we start to live with it. And we say, no, we're going to back. The beauty of this is we can say, you know what? We're not going to do that. We're not going to go there because it's obviously not worked out.
Right. Exactly. So,
yeah. So what do you think? I mean, we're living in a time. You talked about trust in the institutions and the Supreme Court works when it's trusted. When you've got we're living in a time right now where there are certain elements that want to. I mean, it's not that, and I'm not talking about blind trust, right? I mean, I think healthy skepticism of our institutions is always a good thing. But there is just an onslaught in at least the lifetime I haven't seen. I mean, this may have been in the 60s, but I was riding my tricycle then. But an onslaught of people really undermining our institutions at every turn. whether it's the Supreme Court because people don't like some of their decisions, whether it's the Justice Department because people don't like what they're pursuing. That, and again, I want to be clear, I'm not rejecting serious criticism of our institutions, but it almost seems as if we have a cobble of voices. Maybe I should say cacophony of voices. I never use that term, so let me use it today. Cacophony of voices that their task is just for their own ends to just so reduce the trust in our institutions that our institutions struggle to function.
Right. Well, that is the hallmark of authoritarianism.
Yeah.
Is the idea to sow confusion and distrust so much that you can, with your own political power, that you can state how things are going to operate and not be held accountable.
Yeah.
So I think that, and we've always had some element of that in society at various times and expressed in various ways. But yes, I think they're particularly on, not to get partisan here, but just particularly on the right now. It seems to have fallen almost entirely into that sense of, if we're not going to get our way, then we're not going to participate. We're not going to go live in the house that you were talking about that was created by the Constitution. We're going to tear it down.
Because it's not working for us.
Destabilize it so we can tear it down and put up what we want.
Yeah,
that's how it feels to me very often.
And by the way, let me say too, because I've said this before, that right now the authoritarianism that is really coming out is coming from the right. That doesn't mean that left-wingers can't become authoritarian.
That's right.
All we got to do is have a decade or so where conservatives get a lot of what they want, and you will see a lot of left-wing authoritarians wanting to do the exact same thing.
Right.
Because it's not about the process by which we do these things. It's about getting what we want. Right. And if democracy, which is the process of governing, isn't working for us, then we need to do something different. So we need to be what I always say is we need to be careful that authoritarianism is not limited to one's political slant.
Right.
That it's authoritarianism is born when the mechanisms of our government, society, whatever, are not having the results we want, and then one person comes along who says, I can fix it. Right. That's the dilemma. So Congress isn't going to fix it. The Supreme Court isn't going to fix it. Justice Department isn't going to fix it. But this one person here, he will fix it. And so let's go with him. That's authoritarianism.
Right. And I think the danger is that if, in this case, if the right succeeds with its authoritarianism, it doesn't mean that it's going to be necessary to be able to hold on and retain that indefinitely. But what it is going to foster is that the left then begins to abandon democracy, begins to abandon those social institutions, because they see that they couldn't get what they wanted in terms of playing by the rules. The right didn't play by the rules. They got what they wanted. Now those powers that are authoritarian on the left then begin to have more credence and more sway, because they can say, look, now we'll get what you guys wanted on the left. And, and then you end up with competing authoritarian factions.
Our commitment to democracy isn't working, so we're going to become authoritarian, just like the guys on the other side of the aisle. That's a really good point. And so the authoritarianism does not have really anything to do with specific policies. This is the one thing I hear, but it's the policies. People will say, but it's the policies. Stop, throw the policies out the window. Because Hitler got power, people supported Hitler in part because the economy was doing well. I mean, and again, I'm not dissing a good economy. I benefit from a good economy just like anybody. But what happens is the authoritarians get power because the people, even people who don't necessarily support the authoritarian, are willing to allow it to happen because I've got a job. And so what happens, so it's not about the policies, it's about the style. It's about, listen to the language. Listen
Right.
to what is being said. The language matters. These things, and so authoritarians can come from anywhere in politics.
Right.
It's not like left wingers are only authority. I had someone say that to me one time, that only left wingers can be communists and fascists. It's like, really? What under, where did no, I'm sorry. Authoritarians, fascism, whether you want to call it communism on the left or fascism on the right, authoritarianism comes from all political stripes. It's not policies. It's a way of government.
Right.
Which precludes, by the way, what we cherish as our democratic institutions.
And that's if there's a lot of problems with the terms of American exceptionalism, but if you want to use the term American exceptionalism, what has made America that is exceptional is its form of government that it established, that became the model in many ways and various aspects for other places around the world, that has led to greater stability, freedom, prosperity, that type of thing.
Right.
Very imperfect, needed modification. It has grown and improved and needs to grow and improve more. But that is what's there. And if you are not committed to this idea of democracy, the rule of law, the way the Constitution is supposed to work, then you're not American.
Yeah.
But you may be loyal to your society, to your culture, and so on, but you're not American in terms of believing in the American experiment, the American dream that was founded 250 years ago.
Yeah, that's exactly right.
So
and I'll say this again. I've said this before. Democracy ultimately cannot function. I mean, this is true of other forms of government, but democracy cannot be at its best, and democracy cannot bring out, to quote Abraham Lincoln, the better angels of our natures.
Right.
It cannot happen apart from a people who are moral.
Right.
Apart from people who are people of character. You have to be ethically centered, and that what is most important is not what you want, but what is right. I still remember the 2000 election, the contested election, and the Supreme Court finally made the decision about Florida that gave George W. Bush the election.
Right.
And I remember Al Gore with his speech. You probably remember it too.
Right. Sure.
Who got up there and he said, "I vehemently disagree with the court's decision.
Right.
But I respect it. I will abide by it." That was a moment of character for Al Gore.
Exactly.
That was a moment of character.
Yep.
That's not what we're hearing sometimes today.
Oh, not at all. Yeah,
and so this thing cannot be sustained without people of character. John Adams said that the American people will when it comes to character, the American people will get the politicians that reflect them.
Right. Yeah. Right.
If you want people of good character in office, then voters have to be people of good character. Otherwise, it ain't going to happen.
Well, and as I was saying earlier, there is no perfect system. There is no system that's going to guarantee our state, our freedom, our stability. None of that is going to happen by the system.
Yeah.
And I don't think we should be thoroughly disillusioned or disheartened by the fact that there are now challenges to the system that we have, because we've had challenges in the past. Our system is not natural. This is our system of democracy, checks and balances, decentralized government, those type of things. That is not natural to human history. This is something new. This is an experiment we've been trying for a very short sliver of 250 years. And the only way that it continues is that it will occasionally be tested. Yeah. And the people have to decide all over again, do we want to continue with the experiment or not? And that's where we're at right now, is that we have it's a minority, but a loud, sizable minority that says we don't want to continue with the experiment anymore. Yeah. We want to do something different. And so the question is, what's going to prevail? Yeah. Are we going to continue the experiment or not?
Yeah. And again, the checks and balances, again, for all the hubris of the Enlightenment and how wonderful we human beings were now, the founders also understood what happens to human beings when they get power. And that's why you've got the checks and balances. And you're right to say it's against our nature. By the way, this is a very biblical thing. That that there's not something that's wrong with us, right? We're cracked. We're not as we should be. We can be selfish. We can be self-centered, and also, let us be honest and say, at times we can just be stupid about things. And so we need a way to be able to. I need a way to put my own self in check about these things, and so that even when I talk about the character of our leaders, even our leaders are still flawed. They may be people of good character, and I want people of good character in office. But they're also, sometimes they run astray too. And that's what I was reading something a while back, Michael, about term limits, because of course that's always been front and center. We should have term limits. And I was kind of curious. I didn't really know what the founders said anything about it. And I kind of assumed they didn't think about it, but I found out from doing some reading is that yes, they did think about it, because the old Articles of Confederation had term limits. Basically, what I read from constitutional scholars is that the reasons the founders didn't put term limits is because they made the assumption that if a bad politician gets elected, it won't take a politician. They mean bad politician. They mean a politician without character, who's a scoundrel. They made the assumption that the voters would realize it and vote him out of office.
Right. Yeah. Exactly.
They had this kind of view that, well, it can happen. You can get a real scoundrel in there, but it won't take long before the people will realize this person's a scoundrel, and out they go. Not so sure that has fared too well over time, to be honest. Always. Sometimes, it does at times certainly work, but the idea again was they put it back on the American people to say, you know what? This person does not have anybody's best interest at heart. This person is in it for himself. This person is self-centered. This person, and we can't let this person back into office. They assumed that term limits was the vote. If you want term limits, vote them out of office. That was the idea.
That's what limits the term.
That's what limits the term. So anyway, this is good. Michael, anything else we want to say for the good of the order?
I think that's been a good discussion.
It has been a good discussion. And I really would just like to see some more serious conversation about the way all of this works. And I'm concerned. I got to say this. I'm concerned about the current public view perception of the Supreme Court, because over the years, by and large, there's been exceptions. But over the years, when trust of institutions like Congress and the White House and has been at lows, historic lows, the Supreme Court has always sailed above that.
Right.
You can go through history and see it. The Supreme Court always seems to be the respected institution. And I think there are those who have worked to undermine that. Unfortunately. And again, I understand if people at the court makes decisions they strongly disagree with, and that's part of our democracy. We get to say that. We get to do all of that. But I want to say that for those all to work right, there's some deeper considerations that all of us have to reflect upon, whether we agree with the current court's decisions or not.
Right. Absolutely. All I can say is amen. Yeah.
Okay. All right. And no packing the court. We got 9 justices. We don't need if we get too many, I mean, it's hard enough to remember all 9 of their names. If we get 13 or 14, now I'm taking off my shoes and socks to count them all and name them. So we can't do that.
I'm not sure that there's ever been in time where the answer to a problem was to build a bigger committee. So,
well, Michael, you and I are mainliners. We know this. I always said that mainliners, the first answer mainline Protestants have to every dilemma is, let's form a committee. Right? That's
right. Exactly. Right.
And if it's not working right, let's add more members. I mean, no kidding.
Right.
That isn't the solution, because again, by the way, that will come to bite you in the butt. At some point, the court is going to be leaning liberal again. This happens. This stuff goes in cycles. We get so short-sighted about the moment. This all goes in cycles, and at some point, our court is going to be leaning judicially to the left, and so for all of those of you who are Democrats who want to pack the court, you're given precedent for conservatives in the future to do the same thing if they have the power. So
Right.
just stop this conversation. Yeah, we got 9 justices. Let's live with it. You know, there's elections and presidents get to. We should have talked a little bit now. It's, you know, the confirmation process in Congress has become such a joke.
Yeah, right.
It's such a joke. And both parties have made it a joke. That's another issue for another time. Another conversation to have that will not be solved here. So anyway. Right. Well, Michael, thank you again for a great discussion. Friends, thank you. Please don't forget, click the subscribe button and help us out. Leave us a thumbs up and give us any comments and maybe topics for the future, except for the capuchin monkeys thing. Leave us, give us some thoughts. We would love to have that. So this is Faith Seeking Understanding. I am Allan Bevere, and the patron saint of Faith Seeking Understanding is Anselm of Canterbury, who said, "I do not understand in order to believe, but I believe in order to understand." Friends, keep seeking.